Welcome to Prediction News Update. My name is Chris Gerlacher with Prediction News, and we've got some new drama in Nevada, and we finally have a tribal case hearing. So we're going to test out some of those tribal arguments that have been filed, but haven't had a hearing in front of a judge yet until this week. So if you're here with us, like this video, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. Now I'm going to bring in Daniel Wallach. Dan is our appellate lawyer extraordinaire with us, and he's going to help decode what's going on behind the scenes. Dan, I want to start off with Nevada. What is going on in that state right now?
A couple of weeks ago, Judge Gordon in the Crypto.com case denied Crypto.com's motion for preliminary injunction, and the big takeaway from that ruling was his preliminary determination that crypto had not demonstrated a likelihood of success in demonstrating that their sports event contracts tied to the outcomes of sporting events qualified for treatment as a swap. Now, a swap under the Commodity Exchange Act is defined as a contract based on the occurrence or non-occurrence of an event with potential financial, commercial, or economic consequences. And his view was that the statute is based on events, whether an event occurs or doesn't occur, not the outcome of the event. So he split some hairs and found that outcomes don't qualify for treatment as a swap under the CEA, which basically created a ripple effect in the Kalshi case, because now that the judge has been turned around on the issue of federal preemption, because in order for Kalshi's federal preemption argument to work, that the Commodity Exchange Act preempts state law, their contracts have to be swaps or maybe excluded commodities, but they're all tied to the same kind of definition of occurrence or non-occurrence of events with economic consequences. So if outcomes of sporting events aren't swaps for Crypto.com, then maybe neither are they for Kalshi, because Kalshi's own self-certifications that were filed with the CFTC are plainly based on outcomes of things: who wins or loses a game, whether or not someone will exceed a certain statistical benchmark. So naturally, Nevada wanted to avail itself of the same benefit of that ruling in the Kalshi case and filed a motion to dissolve the preliminary injunction. Instead of litigating the case all the way out until the end of the case, which they've been doing anyway, they wanted to at least operate without the cloud of the preliminary injunction, hovering over it. So they've filed an emergency motion to dissolve that preliminary injunction, and Judge Gordon set it for a hearing date on November 14th, Friday, November 14th, the same day he's also hearing Robinhood's motion for a preliminary injunction against the state of Nevada based on the same arguments that Kalshi had raised and that Crypto.com had raised. So by the end of the day on November 14th, I think we may have uniformity in the Nevada federal court system, or maybe we won't. The issue of whether the sports contracts issued by Kalshi involve swaps, that will be squarely at issue in the November 14th hearing. So I think before the end of November, we may get legal clarity as to which way these cases are headed, and they may be headed for an immediate appeal to the Ninth Circuit.
That'll be exciting. And what would a non-uniform set of decisions in Nevada look like? How likely is it, and what would it look like in practice?
I think he's likely going to dissolve the injunction, because if he doesn't believe that this is a swap, I don't see much differentiation between crypto's sports contracts and Kalshi's sports contracts. They're all based on outcomes. What may be different here is that maybe Nevada waived an argument by not sufficiently addressing this at the outset of the case when they had the opportunity to file a brief in opposition to Kalshi's motion for preliminary injunction. Just because they have new lawyers 6 months later doesn't give the new lawyers the right to raise arguments that were not properly raised in opposition to the original preliminary injunction motion. I don't know that there are any such waivers going on, but it could be that these arguments could have been raised but weren't, or that maybe the judge finds some differentiation between Kalshi's situation and Crypto.com's situation, or alternatively, maybe there are some arguments, and I think this is the more likely scenario, that there are arguments that Kalshi's outside counsel will make that Crypto.com's outside counsel failed to make.
Mhm.
One of which might be the language in the definition of a swap, which speaks of the word contingency, whether a contingency occurs or doesn't occur. And I think a contingency sounds more like the outcome of a sporting event than the occurrence or non-occurrence of an event. Again, we're going to go down this rabbit hole of what does an occurrence mean? What does an event mean? What's an outcome? What's a contingency? But the contingent language, or the word contingency in the definition of a swap, was not adequately raised by Crypto.com in its motion for preliminary injunction. And the judge found that they had essentially waived that argument by raising it too late. But nonetheless, he addressed it and decided that the word contingency was not a sufficient loophole in which to fit the outcomes of sporting events within. But Kalshi may have much more to say about that issue. And I think they've previewed their argument by filing papers in the Third Circuit U.S. Court of Appeals in relation to New Jersey's filing of a notice of supplemental authority, where the state litigants across the country were very quick to waive the Crypto.com ruling in front of the judges in all the other courts. And Kalshi responded last week to New Jersey's notice of supplemental authority by highlighting the fact that a number of dictionary definitions define outcome and event as almost interchangeable, that they mean one and the same thing, and that under the CFTC regulations, the CFTC understands events to encompass outcomes of events. So I think Kalshi has previewed its likely argument in their Third Circuit response to New Jersey's notice of supplemental authority, and they're going to make the same arguments, or I think embellish upon those arguments. I don't mean embellish like lie about them, but expand upon those arguments when they file their opposition papers in the Nevada court. So just because, simply because Crypto.com didn't carry its burden doesn't mean that Kalshi would be unable to. It might be a function of how effectively Kalshi argues the case relative to how ineffectively or effectively that Crypto.com argued it. So I don't think it's a guaranteed same outcome, but it sure seems to be pointing that way.
That is some high stakes, hair splitting from the dictionary that we're going to get there in a month, huh?
Yeah, but I think what a lot of people are ignoring in focusing on the words is that Judge Gordon also looked to the issue of congressional intent and concluded, or at least preliminarily determined, that his interpretation of the swap definition was consistent with the legislative history of the Dodd-Frank Act and the debates and the conversations which occurred between Senator Lincoln and Senator Feinstein, that not wanting to have gambling conducted on the derivatives market. So he used a lot of the same tools that Judge Abelson used in Maryland to arrive at the same outcome of denying the motion for preliminary injunction. But I think the safer path was chosen by Judge Abelson, who said it does not matter whether these event contracts are or are not swaps. Let's assume that they are, given the longstanding congressional policy of being antithetical to sports betting through the Wire Act and PASPA, and how it might constitute an implied repeal of IGRA. I think Judge Abelson and Judge Gordon used used congressional intent as the touchstone for analyzing the question of federal preemption. It's just that Judge Gordon took on the riskier gambit of also concluding that it wasn't a swap because it involved an outcome rather than the occurrence or non-occurrence of an event. Judge Abelson wisely avoided that question, and I think his ruling may be more bulletproof on appeal than Judge Gordon's anticipated ruling in this case will be. So that's the risk of trying to thread all those needles when I think he could have just simply focused on the sole question of congressional intent.
I do not envy that man's job right now, untangling all of that. But I want to pull you into California.
He's chief, and you got lifetime tenure. I don't think
that's a pretty good perk.
Yeah, I don't think he goes to bed at night worrying about his about getting fired. It can't happen. So to be an Article 3 federal judge, presumably you have to be a pretty talented lawyer with a lot of accomplishments within the legal profession. So he'll figure it out. But he's made his task infinitely more difficult by maybe taking on more than he needed to.
No, best of luck to him in that regard. And in California, we finally got our first hearing in the tribal case. Give us a rundown of the major arguments and how the judge in that case was receiving them.
Yeah, there are two main arguments here that the California tribes were advancing. And the first one dealt with by the court involved the Lanham Act.
It's the False Advertising Act, right?
Yeah, the Kalshi claim, I'm sorry, the tribe's claim here is that by falsely advertising that they're legal sports betting, Kalshi is engaging in false advertising in violation of the Federal Lanham Act, and that the tribes, as competitors of Kalshi, even though they don't offer sports betting or sports contracts, are injured. And that claim was just like shut down right at the outset of today's hearing. The judge was not even remotely persuaded by the California tribes' Lanham Act argument. So I don't want to spend a lot of time on that, but it sure seems to me that if the California tribes have any hope of prevailing in that lawsuit, it's not going to be because of the Lanham Act. It will be because of the Indian Gaming Regulatory Act. And the idea that these sports event contracts are available throughout the entire state of California, naturally, they were also available on Indian lands. So if you're a customer of Kalshi and you're visiting a tribal casino and you're buying or selling or entering into a sports event contract, you're doing so on tribal lands. And the tribe's argument here is that the only kind of gaming that can occur on tribal lands is pursuant to a state tribal compact. And in order to be able to offer gaming on Indian lands, you need a state tribal compact, you need the passage of a tribal ordinance, and you need the federal government through the Department of the Interior to approve that compact. So the key issue on the IGRA claim is, are these sporting event contracts in effect Class 3 gaming on Indian lands that would require a compact? And even if so, does the Unlawful Internet Gambling Enforcement Act override IGRA, because IGRA traditionally has been synonymous with gaming on Indian lands, whereas the Unlawful Internet Gambling Enforcement Act deals more specifically with the subject matter of internet gaming, and that statute has an exception or a carve-out for contracts traded on CFTC-regulated markets. So Kalshi's response to the California tribe suit is that this activity, to the extent it's illegal at all, is only covered under UEJA, not covered under IGRA, and our contracts are traded on CFTC markets, and those contracts are covered under an exception within IGRA, within UEJA, excuse me. Right. So that's sort of the back and forth. And listen, I disagree with Kalshi's position that IGRA only reaches land-based gambling operations. There are cases, in particular the West Flagler versus Haaland case involving the Florida Seminole Compacts. The Seminole Tribe of Florida's compact that involved internet gaming, whether it's on tribal land or off tribal land. And the question was, where does the bet occur? So the internet bet is deemed to occur on tribal lands because the state and the tribes have agreed to it. So jurisdictionally, I'm not necessarily agreeing with Kalshi's view that IGRA is strictly limited to land-based gambling operations. There are a few cases which have extended IGRA's reach to internet wagering. So the problem is that Dan Wallach didn't orally argue that case. Joseph Webster did not orally argue that case. Some of the leading tribal gaming attorneys didn't argue that case. It was handled by another tribal attorney who I think missed the mark on being able to convince the court why IGRA trumped or overrode the UEJA, because that was really the core of the issue. And if the judge believes that internet gaming on or off tribal lands is covered by UEJA, and that UEJA has that carve out for Kalshi's contracts, Kalshi wins that motion. And based on you watch I want to hear what some of your takeaways were from watching the oral argument on Zoom. But I thought that unless this judge goes into the library and does all of this research on her own and rescues victory from the jaws of defeat, I think this is going to go down as a denial of the California tribe's motion for preliminary injunction. And it was an eminently winnable motion on the IGRA claim. It really was. But I don't think the tribe's lawyer did a good enough job in bringing her across, the goal line on that one.
Sure. I have a harder time reading this than you do. What was it about the judge that makes you think she's, can you tell if she's leaning in one direction or the other, or is it just on that point that you think she's not quite there?
That's a great question, because there was a duality to her approach during the oral argument. I think she was, she was skeptical on some of the IGRA-related claims that the tribe's council made, but on the other hand, she was very sympathetic to the notion that all that the tribes have are their Indian reservations and what occur on their own lands, and that the tribes are not on this march to eradicate Kalshi all over the United States. They're concerned about their own Indian territories, and that's where the tribes exclusively conduct gaming, and IGRA grants the tribes exclusive sovereign authority to regulate gaming on their own lands, and the only gaming that can occur on their own lands is pursuant to a state tribal compact. Easy argument to make. There's case law supporting the application of IGRA to internet gaming, but the tribal attorney missed the mark. But where she may have given some optimism to the tribes, not only these tribes, but tribes all over California, is that she wanted to know on a personal level, forget the legal aspects of it, why does Kalshi insist on intruding tribal sovereignty and offering this gaming product on tribal lands? Is it really that important for Kalshi to compete with the tribes on their own land when the tribes, gaming operations provide economic sustenance and, provide for so many families? That's the chief revenue raiser on tribal lands. And yet this, national commodities company that's worth $10 billion now wants to corner the market, not only throughout the United States and throughout various different states, but also wants to compete with the tribes on their own lands. And she had a fundamental problem with the sort of morality behind that. And that could be an important development, because I think she's sensitive to the tribe's position, but she needs to get in their corner on the law. And the tribe's attorney today, I don't think, threaded the needle. I don't even think you needed to thread the needle. Chris could have argued it. I could have argued it. I was not really that persuaded by how he argued the case. If this were handled by any of the forces of tribal gaming lawyer, I think we'd be having a completely different conversation now. But she's a very smart jurist, whip smart, sensitive to the situation that the tribes face here, and is looking for a way to rule for them. Does she get there? Potentially, but I don't think the tribe's attorney did their clients any favors here, and she's going to have to figure it out and go to the books and analyze this issue, which suggests to me that the ruling may be a while coming, and it may not be an overnight or next week type of thing. I think she took an hour and a half of her time to hear competing oral arguments, and she's not persuaded. She may not be persuaded either way. She's going to have to do a lot of supplemental research on this, and just take it under advisement. I think we're looking at potentially late November before we hear anything. But my prediction, if we're on prediction news, is that I think she's inclined to deny the tribe's motion for a preliminary injunction. And it just goes back to what I've been saying over and over and over again, dating back to the first Nevada case, the New Jersey case, the quality of the lawyering. And I don't want anyone getting mad at me because I'm criticizing any lawyers, but I think Kalshi's counsel did a much more effective job at the oral argument than the tribe's counsel did. And that may have made the difference.
What makes a strong versus weak oral argument from a lawyer's point of view?
I mean, there's some people, Kalshi is using Milbank, and they have, they're veterans of this saga. They're now on their fifth or sixth oral argument, filed probably in excess of a dozen briefs already. They have a mastery of this subject matter and all the sub-issues and retorts to sub-issues. They have a mastery of the subject. That doesn't mean that they're right.
Mhm.
And today, Kalshi's attorney, again, it kept advancing the fiction, the one that you and I have talked about at the at panels. That's
Mhm.
that the CFTC has the ability to do a case-by-case public interest review, the so-called two-part test,
Mhm.
which is just mythical and fanciful. It doesn't exist. But Kalshi's attorneys kept arguing that today, and the tribe's attorney wasn't really didn't catch them on it or call them out on it. And I think it does make a difference
Mhm.
how prepared and how much experience Kalshi's outside counsel has in having litigated these cases. They have just each successive case, they have it down to a T.
Mhm.
Whereas this tribal attorney, I think his name's Lester Martson, he did a nice job, but he wasn't as effective as Kalshi's outside counsel. And again, we're going to get potentially a third result here that may be less law driven and more lawyer driven.
Mhm. Yeah, that'll be really interesting to see how that plays out after the
You
preliminary.
didn't say anything about my suit.
Yeah, well, you were what 20 minutes in. Well, of course you have a stunning suit. I mean, you've outdressed me. This is my formal T-shirt, that I threw on real quick for this, but.
Well, worlds collide today. Big news broke in the NBA regarding
Mhm.
the arrests of Chauncey Billups, Damon Jones, and Terry Rozier. And I got a lot of live TV work today, so I had to throw on the suit. And you and Prediction News are the beneficiary of that sartorial choice.
No, I mean it is a stunning suit, and it makes all the difference, I think.
Just like good lawyering makes all the difference in some of these cases. A
Right.
good suit may not make a difference at oral argument, but it does maybe help a little bit on podcasts and television. A little bit makes me look a little bit more respectable. But in the court, everybody's wearing a suit. We all look the same: charcoal gray, navy, a light blue, dark blue shirt. It's almost like a standard uniform.
Not everyone has that great hair, though. But I do want to ask you real quick. After we get a preliminary injunction decision in California, what are the next steps after that? How soon do we get to the appellate level and start talking about standards of review and Indian canon?
Okay, well, we didn't talk about that yet today. I think what might happen is you might see some effort made to file supplemental briefs. One of the concerns I had was this is one of the few cases Joseph Webster and Scott Crowell and Brian Newland and Michael Honig, sort of the cabal of tribal gaming lawyer extraordinaires that have been filing amicus curiae briefs in Massachusetts, Nevada, the Third Circuit. They may want to weigh in here. They may want to ask for a leave to file a brief here to kind of turn the judge around on the UEJA issue or on the IGRA issue generally. So I wouldn't put that out of the possibility or realm of consideration. But I think what will happen is that this is going to be a denial, in all likelihood, a denial of the tribe's motion for preliminary injunction. And they're going to have the right to appeal that to the Ninth Circuit U.S. Court of Appeals. And I don't think they've waived any arguments, but I think the saving clause here for them might be the de novo standard of review at the Ninth Circuit and basically having a second bite at the apple.
Okay. And what is that standard of review, quite briefly?
It's going to be, on pure issues of law,
Okay.
issues of statutory interpretation. There's no presumption of correctness given to the lower court's decision. It's de novo as the standard of review, which means that the appellate court will consider the issues anew as if the lower court had not yet decided them. So I think at that juncture, when it goes to the Ninth Circuit, along with the Crypto.com and Kalshi and Robinhood cases, you could have parallel Ninth Circuit appeals, and I think the national tribes are going to file amicus briefs in both of those cases. So it's a setback only in that, in my view, it was a lost opportunity for the tribes. They should have won this motion, at least on the IGRA ground, because if you can't convince a federal judge that offering a sports wagering contract over the internet within tribal lands is not an IGRA violation, I don't think you're doing your job well enough. I really don't. And the only pushback on that, and it was a concession that Kalshi's lawyers made, that if it wasn't for the UEJA carve-out of allowing for contracts traded on CFTC regulated exchanges to be excluded from the reach of UEJA, that but for that carve-out, he conceded that the tribes would have a pretty good case. And that concession may come back to haunt him. but I think it is a lost opportunity. And is it fatal? Does it mean that the states are going to lose? Does it mean that the tribal amicus briefs in other cases are going to be affected? Probably not. But this can be precedent. And if the judge denies the motion for preliminary injunction and determines that the UEJA carve out for commodity contracts overrides or preempts or supplants IGRA, that's adverse precedent that is not in the tribe's best interest, and it's precedent that favors Kalshi and could potentially be used as ammunition in all these other federal court cases where the tribes and the states are arguing that the CEA interpretation constitutes an implied repeal of IGRA. So even though Joe Webster didn't litigate this case, the impact of today's ruling, if it goes against the tribes, could potentially be harmful in some of the other pending lawsuits, depending on how Judge Corley interprets the interplay between UEJA and IGRA.
Okay. That's going to be a lot to untangle as well. I know you've got a hard stop coming up, and I know we've covered those two main states and cases. Do you have any final thoughts on quick developments in Ohio and the tribal brief in Massachusetts?
Yeah, two developments in Ohio this week. The judge, after no docket activity for 2 weeks, the judge set a November 3rd preliminary conference. I think ostensibly to talk about the briefing schedule and the argument date for Kalshi's motion for preliminary injunction against Ohio. And then earlier today, not yet reported by anybody, but Kalshi and the state of Ohio filed a joint stipulation or joint motion requesting that the Ohio federal court extend the briefing deadlines by a couple of weeks. And the upshot of it is that the last brief in connection with Kalshi's motion for preliminary injunction will be filed in early December, which means we probably won't get a hearing date on the PI motion until the first, second, or maybe even the third week of December, with the possibility of a court ruling not occurring until early in 2026. So today's events, coupled with the scheduling of an informal conference, I think has kind of kicked the can in Ohio down the road, at least by a couple of weeks. I was hopeful that there would be a decision by mid-November, but I think that date is long since been blown by as a possibility, and we're now looking at mid-December to early January with an oral argument likely in the first half of December.
Okay. And then what happened with the tribal brief in Massachusetts? What's interesting in there?
Yeah, I went on Victor Roach's podcast yesterday, and I was extolling the virtues of the tribal amici brief that was filed in the Robin Hood versus Massachusetts case. Anyone who believes that Kalshi's legal argument as to federal preemption is a flawed legal argument, you need to read the tribe's amicus brief. It was co-authored by four of the most preeminent tribal gaming attorneys in the United States: Joseph Webster, Michael Honig, Scott Crowell, and Brian Newland, who used to be the Assistant Secretary of the Department of the Interior. They laid out all the arguments for why Kalshi's interpretation of the Commodity Exchange Act would constitute an improper implied repeal of IGRA. And in addition to taking on the IGRA piece, the tribal gaming attorneys also effectively, in my view, argued the lack of preemption under the Commodity Exchange Act. And they did a really credible job, a first-class job in briefing the CEA, CFTC type issues in addition to IGRA. So I think that's going to be the blueprint that tribes are going to be using across the country for arguing why Kalshi sports event contracts constitute an applied repeal, if not an outright violation of IGRA. And those, I think, could be influential in Massachusetts, could be influential elsewhere. The tribes filed it in the Robin Hood case last Friday, and will file it in the Kalshi case, presumably at some point between now and when the motion for remand is heard in Massachusetts on November 12th. So the importance of the tribal amicus brief is I think it represents the most compelling legal advocacy, in my view, in the entire the entire trajectory of Kalshi versus state or state versus Kalshi litigations. I think it's going to be a formidable argument that Kalshi is going to have to contend with that could be a difference maker in some of these cases, as it was in Maryland, and as it was in the Nevada Crypto.com case. So at least as things stand today, I think Massachusetts could be the swing state in the sort of, whether Kalshi continues to advance and win cases, or whether the states win their third in a row. And I think the outcome of the Massachusetts motion for remand could have far-reaching consequences going beyond Ohio, particularly if the state wins, because if the state wins, as I've discussed during the last episode, it gets kicked back to state court, and the state is much more likely to prevail on state law claims in front of a state court judge in a state court than they would in a federal court proceeding, where the issues of federal law may be more meaningful. So the Massachusetts ruling on a motion for remand is, I think, almost like a game, set, and match for how future cases could be decided. That's why the tribe's amicus brief, at least in my opinion, is a very important piece of legal advocacy given the stakes in Massachusetts.
Well, the prediction market fights have gotten so intense now that Massachusetts has become a swing state. That's just remarkable. Well, Dan, thanks so much. Oh, go ahead.
No, I mean, to call any licensed sports betting state a swing state is remarkable. That Kalshi had been winning and prevailing in states like Nevada and New Jersey that are synonymous with casino gambling and legal sports betting, and yet the federal judges in those cases recognized, or at least preliminarily determined, that the federal commodities law overrode all those state gambling laws, basically going into the lion's den and winning a road game on somebody else's turf. But I think the pendulum may have swung back a little bit with the Maryland ruling, the Crypto.com ruling, and Kalshi's own actions in aggressively expanding into parlays and props and going overseas. Their narrative back in April and May was like Super Bowl, the Masters, television ratings. Now they have to account for the types of event contracts that look a whole lot more like the prop bets and parlays that are available in state licensed, state regulated sports wagering regimes. And that's one of the arguments that Nevada is making in seeking to dissolve Kalshi's preliminary injunction. They're arguing that the landscape has changed significantly by virtue of the Crypto.com ruling, the Maryland court decision, and Kalshi's own actions in aggressively expanding beyond tentpole type of sporting events to now include individual player performances within games.
Mm-hmm. Yeah. Well, Dan, thanks so much for breaking down all those cases for us. If you're still here with us, like this video, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. Dan, I'll be watching for you on all your television appearances during the NBA scandal stuff.
Yeah, you can't avoid me today. I'm everywhere.